All right, good morning, everybody.
Good morning.
And thank you for coming to this session. Just so you know, this session is on collective bargaining in Virginia and what you need to know. My name is Tim Hemstreet. I'm the administrator in Loudoun County, and I'll just be serving as your moderator today. What I'm going to do is first introduce our panelists who are here to explain what our new frontier looks like and how to put together an ordinance in your locality if you want to proceed into collective bargaining. On the panel today, we have several very knowledgeable individuals. I'll start with Senator Jennifer Boysko. Senator Boysko represents the 33rd District, which includes parts of Loudoun and Fairfax counties. She focuses her efforts on creating an economy that works for all by improving schools and workforce training programs, fighting for equal pay and paid family and medical leave, supporting business to create new jobs, advocating for our diverse population, and for residents who often don't have a seat at the table. She served in the House of Delegates from 2016 to 2019 and in the Senate from 2019 through the present. She currently serves on 5 Senate committees: General Laws and Technology, Judiciary, Privileges and Elections, Rehabilitation and Social Services, and Transportation. Senator Voisko is chair of the Broadband Advisory Council, vice chair of the Commission on Civics Education, and the Senate representative for the Northern Virginia Transportation Authority. Senator Boysko graduated from Hollins University. Senator Boysko will go first in a few minutes. The next person on our panel is Cynthia Hudson. Cynthia is currently an attorney at the law firm of Sands Anderson PC. Prior to her position at Sands Anderson, she served as Chief Deputy Attorney General for the Commonwealth of Virginia. In addition, Ms. Hudson served 8 years as City Attorney for Hampton and the preceding 7 years as the City of Hampton's Deputy City Attorney, responsible for civil litigation and general counsel to the city's human resources, police, and fire departments. Ms. Hudson previously worked in private practice, specializing in labor and employment law, training and litigation, and support of government clients. At Sands Anderson, Ms. Hudson's focus is on advising and representing state and local government entities on areas including collective bargaining, dispute resolution, and employment law, compliance with government administration statutes, public policy development, governance, and government affairs. Ms. Hudson is a graduate of Virginia Commonwealth University and the William and Mary Law School. And then our third panelist is Eric Paltell. Eric is a partner in the law firm of Kollman and Saucier, PA, and is the managing partner of the firm's Virginia office. He has practiced law since 1987, concentrating in the representation of private employers and local governments in all aspects of labor and employment law. For more than 20 years, Mr. Paltell has devoted a substantial portion of his law practice to public sector collective bargaining, including first and renewal contract negotiations, grievances and arbitrations, impasse proceedings, and unfair labor practice charge proceedings. Mr. Paltell is a Phi Beta Kappa graduate of the University of Virginia, where he received a BA with honors, high honors, in 1983 and a JD in 1987. He is licensed to practice in Virginia, Maryland, and Washington, D.C. Those are our 3 panelists. We will start with Senator Boysko, who will talk about the implementing statute. She is one of the patrons for the statute. One of the things that was important was having local choice, and so she'll talk a little bit about that. Ms. Hudson will talk about how to put an ordinance together. I believe you assisted with the ordinances in Fairfax and Arlington counties and the city of Alexandria. And then Mr. Paltell will talk about, okay, now that you have an ordinance, what happens now? What do you do to negotiate your collective bargaining agreement? You have your agreement. What do you do then? The last thing I've been asked to mention is that I have been in Loudoun County as the administrator since December 2009. However, prior to that, I spent about 17 years in Florida in various local government positions. Florida has had collective bargaining at the local level for public sector employees for a long time, longer than I've been there. And so part of my practical experience in those places was also to deal with collective bargaining from all aspects, beginning with negotiations to managing the contract I was a grievance hearing officer for 3 years, to administering the contract and those kinds of things. So while I'm not on the panel, I can help them ask questions that will help you understand what happens once you have an ordinance and a CB in place. So with that, I'm going to turn it over to Senator Boysko.
Great, thank you. I don't think it's active. It's not active.
There's no amplification. All that is so people who are online can hear.
So hopefully the people online can hear me. I'm Jennifer Boysko. I'm research in the district, which includes parts of every magisterial district in Loudoun. Three magisterial districts in Fairfax County. No Dulles Airport is. That's basically the target district, just so you have a perspective of where I represent. I am originally from the South, from Alabama and Arkansas. I understand and one of the reasons that I chose to carry the bill that ended up as the collective bargaining is to give employees and folks who are involved in local government a seat at the table. What does that mean to us all? Right? Being able to sit with the people who are making decisions, to give your input when they are making the final decision about how policies are. SB 939 was passed in 2020. It went into effect this past May, and it amends the code of Virginia in 40.1-55, -57.2, and -57.3. Let's just talk about what our policy doesn't do before we start talking about this. One, it is an enabling legislation, which means if your community chooses that they want to embark on a collective, they have the ability for the first time. Nobody is forced to do it. Secondly, striking in public employment is not allowed. This does not change that. Thirdly, probably most important to all of you all who serve in the body is the elected body continues to hold power, meaning that it is the elected bodies who set the budget, and the collective bargaining has to work within the scope and boundaries of what it is. Nobody can say, we insist that you pay us $5 million if only. We just wanted to make sure that we are on the same page as we get started. So we have a budget. Is there anybody in this group already started a okay, so we have Loudoun County, we have Prince William County, we have Fairfax County. Anybody else in the is interested in embarking? Okay, where are you from? And are there people here in the audience who are concerned about collective bargaining and not? Okay, but it's already been done, right? Yes, sir. Okay. I'm hoping that we can talk about what it is that you're scared about and maybe allay some of your concerns. I was just in Nottoway on Friday. I went down to the retreat, and in my capacity as I've been vice chair and spent some time in Nottoway County. So appreciate your concerns. So let's talk about has it happened anywhere else? Are y'all aware that 47 other states already almost every other state that leaves two other states. When we talk to employees and voters in general, 68% of Virginia voters support employees having the right to vote. Already talked about where they are headed. Charlottesville, Loudoun principal, as well as other local creating their collective bargaining. And as I said, 47 other states and DC have already had, and it's working for them. When people have a seat at the table, when they are able to have a conversation with the people who are in charge, they're more likely to be, they're more likely to stay engaged. They're more likely to feel empowered. And they're more likely to one of the things that I often talk about, and that's what I do as an elected official. I should have listened to their input. Sometimes I don't agree with them. Sometimes I don't take everything that they say, but knowing that they are heard and listened to. There are also data which says that improving compensation and increasing helps reduce turnover and lowers the cost of service quality. If somebody's unhappy, they can say, oh, the boss said then if they leave, you got to train hard to do especially right now. It's pandemic when people are leaving the workplace. You got to do something to bring people back. If you care about voting, union members are 12% more likely to vote. And union workers play a positive role in this improved service to our constituents. And that's what we're all about, right? And so I would say during the pandemic, nursing homes with collective bargaining had 30% fewer deaths than nursing homes without clean work site, paid sick days, and other safety standards. One of the things that I think is important for us to think about is say, you know, the school board is, they're an elected body who are making decisions. But if they don't know exactly what they are not spending, Johnny, Sue, and Bobby understand what the challenges are. And the administrators who are making those decisions miss out on it. It's important to have them at the table. And we're not just talking about the ability for somebody to switch, you know, co-teaching and other kinds of just collective bargaining improves pay and benefits for all workers, but it also provides transparency and pay rates. I care a lot about Virginia and the United States. We know that our pay benefits cents on the dollar. Collective bargaining provides transparency, pay rates, standards for promotion, raises. They've been found to lift wages for the Black and female workers, white and male workers. They help Hispanic and Black workers in the public sector earn more than their private sector. And again, when people understand what one part, not every, you know, not running the show, they do better. If you think of anything else, right, are the power. We always, when we had a big family together, when they were old enough to pass, we made a many of our localities, counties, cities, they do this informally. So I would have to get this conversations, but I think I also will say there is nothing on the table that I'm aware of that I do not serious you know, you want to if this is not something that you want right, we want Virginia to work together.
Again, we'll have time for questions at the end. But now we'd like to go to Cynthia Hudson. We will talk about how to put an ordinance together if you're ready to go ahead and implement collective bargaining in your locality.
Thank you, Tim, and good morning. Good morning to all of you, and thanks so much for the privilege of speaking with you this morning about this subject matter, which has occupied a considerable amount of my time over the last year, thanks to some of the localities that I think Tim mentioned, where I was involved in assisting staff as they navigated the policy decisions to recommend to you all, the elected governing bodies, regarding this new frontier, as I'm fond of calling it, collective bargaining. It's not brand new in Virginia, but it's certainly newly revived, having been passively allowed until about 1977, when the Supreme Court invoked the infamous Dillon Rule and said, well, where are you getting this authority, localities, to collectively bargain with your employees? It's certainly not in any enabling legislation. We don't believe that it can reasonably be inferred from any express rights that you've been given. So with that, and a 1977 decision that actually involved Arlington County as the public employer in the suit, the Supreme Court called into question the ability of local governments in Virginia, or any public employers in Virginia, to collectively bargain with their employees. And just in case local governments hadn't heard the Supreme Court, the Virginia General not only made it clear that that there was not that legal ability, but indeed that it was prohibited, and passed an express prohibition. That was in 1993. So since at least 1977, the law in Virginia, whether case law or statutory, has been that Virginia local governments or other government employers may not collectively bargain. That all changed with the legislation that Senator Boysko just described, which is now codified at Virginia Code Section 40.1-57.2, which essentially lifts that prohibition, but solely as it pertains, as you know, to you all, to towns, cities, counties, and to school boards in those counties and cities. So with that, let's talk a little bit about what is indeed involved in building a collective bargaining ordinance. If you decide to do so, as has been pointed out, it is purely optional. And of course, what is optional can be tempered by so many factors. It may be legally optional. Sometimes it's not practically optional or politically optional, as I know many of you understand and appreciate. So, but I will leave the policy discussion around that to Senator Boysko and to you all as legislators and the lawmakers. But unlike collective bargaining, as has been enabled under typically state statutes in the 47 other states that have permitted collective bargaining for decades now, Virginia's is not a comprehensive statutory framework for collective bargaining. In fact, it really at its essence is purely just enabling legislation. It doesn't tell you how to do it. It simply says that you may. And under certain circumstances, you will at least have to consider it, however, and that part is not optional. As 40.1-57.2 provides, you may do this, but you must at least consider it if certain conditions are met. And that is that a group of employees who believe themselves to be, by their own determination or self-description, an appropriate unit for bargaining, certifies, and I'm using these air quotes to indicate anything that's not defined in the statute, but it's the language from the statute. If they certify that they are interested in having their governing body vote to provide for collective bargaining, then the governing body shall do so. Vote to adopt or not adopt an ordinance, or in the case of a school board, a resolution, within 120 days of receipt of that certification. There's a whole lot, with all due respect, Senator Boysko, that is not answered within that terminology. What does the certification have to look like? What form does that take? Exactly how does a group of employees go about self-describing or self-determining an appropriate bargaining unit? Does the governing body have to accept that as appropriate because the employees say that? How often does a governing body have to revisit the question possibly of considering a collective bargaining agreement? Let's say the firefighters certify in 2021 that a majority of them seek for the governing body to take a vote. And then in 2022, it's the police. And then in 2023, it's the public works employees and other laborers who seek to have the governing body vote on collective. Does there have to be a vote each time? Certainly not. But these are, at least in my estimation, many of the lawyers around the state who are trying to construe these terms and advise you and your staffs with respect to how this works understand and appreciate that we're probably going to have to wait for court interpretation, for attorney general opinions, and others, because reasonable minds can differ about what all of this means. And so far, we've been managing as we might by resort to what we call the usual rules of statutory construction. For instance, certify, if you look up the plain language of certify, and dictionary definitions and law dictionary definitions are available to address this. Certify typically means something sworn, something attested to as evidence of a state of affairs. So perhaps there is something in the form of a petition that is signed by a number of employees who self-describe as a bargaining unit. Maybe it's put forward by a union, however, who's collected those signatures, or maybe it's put together and put forward by just a group of employees on their own. But the statute speaks to employees and employees certifying it. So something that's in the nature of a sworn or attested to document with names of employees, I think is in order. I think too that gives the governing body the ability, indeed I think the obligation, to verify that those are indeed signatures of current employees and expresses a current desire, and some ability as well to determine whether or not it thinks that's an appropriate bargaining unit. But at the very least, I think as a threshold matter, that gets you to the point of this statute that is not optional, and that is over that threshold where a governing body is compelled within 120 days to vote to adopt or not adopt an ordinance. There is much question about voting to adopt or not adopt. And what does that mean? Does it simply mean that you can vote to express your inclination to adopt or your inclination to decline to enable, and that satisfies your obligation during the 120 days? Possibly. These are questions that are roiling right now in local government jurisprudence as it develops around this topic. And as you know, pronouncements of lawyers are not law. They are simply the opinions of those lawyers. And if you have 10 of them in a room, you might get at least 8 different at least 8 different opinions. So the opinions that I express here today are mine, but I do believe that in these areas of undefined language in a statute, by reasonable resort to the usual rules of construction, that we can come to some reasonable understanding in the absence of any authoritative guidance right now as to what they may mean, or at least what puts you on sure footing or reasonable footing if you have to defend a decision against, say, a declaratory judgment action or some challenge to an approach that you've taken. One of the things that I've done is put forward in jurisdictions where governing body isn't quite sure what it plans to do, that isn't quite sure that it even knows what collective bargaining really is in its essence, much less whether or not they want to enable it, but at least put something out there that helps to guide that decision-making process if they are confronted with this purported certification from a group of employees. And I know there are a few jurisdictions who have actually adopted a procedure that dictates exactly what form the certification should take, to whom it should be directed, a particular amount of time in which a designated official of the city, typically the chief administrative officer, whether it's the city manager, county executive, county manager, has to act to receive and then validate, confirm the names as of current employees, people who are probably not managers, not supervisors, so that you feel comfortable putting before the governing body this information as a certification that requires their action. It then talks too about what processes perhaps toll the 120 days. For instance, if the 30 days or the time period in which the administrator is trying to validate the names, it turns out that, well, 50% of them are employees in the next county. Not that that would happen, but clearly that's not a majority of employees in that governing body's jurisdiction that triggers their requirement to act. At that point, the 120 days stops running. And unless that's fixed within a reasonable amount of time, then that 120 days does not continue to run. But these are all things, again, that have been put forward as what we believe are reasonable approaches to manage your responsibility under a statute where there's not a lot of detail right now. And I do believe that the Dillon rule supports your taking that approach. I believe that you can reasonably infer from the power, the express power that you have to enable collective bargaining or to decline to enable it in this way, that you have the power then to at least enunciate a procedure by which this vote has to take place. So with that said, what are we talking about with collective bargaining? How is it different from what you're able to do or what you were able to do before May 1st, 2021, when the legislation became effective? Before 2021, your employees were able to form and join unions. They had the constitutional and statutory right to do so. They still do. Before May 1st, 2021, you were free, as were school boards, to meet and confer with organizations of your employees who were seeking to promote what they saw as their better interests, known as meet and confer informally. What has changed with collective bargaining effective May 1st, 2021, is that you now have the ability to undertake the legal obligation to sit down and negotiate with an entity that is the elected representative, the chosen representative of a particular group of employees. You're required to do that because you've imposed it upon yourself by ordinance. And in that process, you have legally obligated yourself to undertake negotiations in good faith to reach a legally enforceable contract that governs the terms or some terms and conditions of the employment of those employees in the unit. That is the game changer. The legal authority to negotiate to an enforceable contract. And it is a game changer. It is a sea-changing kind of authority that effects such a fundamental change in workplace dynamics that I'm not sure we always appreciate the fundamental nature of that change in considering collective bargaining. Because at its essence, what it does is create shared decision-making that didn't exist before. Or at least it compels shared decision-making, I should say, that perhaps didn't exist before. I would expect that all of you in each of your jurisdictions, no matter how you feel about collective bargaining as a legal matter and as something you would enable or not enable, have authorized or are perfectly comfortable with your chief administrative officers sitting down with groups or representatives of groups of employees and hearing what they have to say. It's certainly more efficient than having, one of three, each of 3,000 employees try to get audiences with their managers and with the chief administrative officer or with the head of the governing body. So it promotes efficiency in terms of the employees having collectively decided that this organization and this individual in this organization speaks for us, and therefore could perhaps take advantage of the open door policy that most localities have to hear from their employees. But in this situation, I believe that appreciating that right now, even with that informal and not legally required discussion and engagement with employees, right now, all the apples are in your basket as it pertains to employee terms and conditions of employment, except as matters may be dictated by state and federal law or by existing laws that you have in place, certainly with respect to protected categories of persons and anti-discrimination laws and Fair Labor Standards Act and similar state wage and hour laws that dictate certain minimums and certain prohibitions in how you treat employees. Those things are set. Those things stay in place. You cannot alter them by collective bargaining. They'd be considered illegal subjects of collective bargaining, at least if you were trying to diminish or in any way lessen the rights of employees under those statutes. But beyond that, the decisions are yours as to what you pay your employees. Your decisions are yours as to how much sick leave they get and how it accrues or doesn't accrue and whether they get paid for any of it after they leave employment and whether they're eligible for retirement and how soon, whether or not police get to take home their cars, whether or not they get a uniform allowance or a weapons allowance. All of those are your decisions using yours, the collective management, obviously pursued through your professional staff. In collective bargaining, you decide to peel away and peel off some of those rights that are presently exclusively yours, some of those decisions that are exclusively management's to make. And the thing you have to decide at the threshold is whether you want to do that. So when it's do it or not do it, fundamentally, that's what you're trying to determine as a policy matter in collective bargaining right at the beginning. So with that, I'm going to run through really quickly so that I don't encroach on Eric's time, just some of the building blocks, which are policy decisions that go into actually crafting an ordinance that enables collective bargaining, if, again, you choose to do it with the understanding that what you are buying into is some level of shared decision-making, and the amount, how much you share, is kind of what's determined by these provisions and the policies or the choices that you make in each of these areas. And let me just say very quickly before I leave some parts of this slide. I'm sorry, excuse me, I forgot that you, I'm following on my computer. You can go all the way over to slide 9.
All right. I'm catching up.
Thank you. I just wanted to make the point to remind everyone that not only did the General Assembly exclude state employees from the ability to collectively bargain, or state employers, employing agencies from the ability to collectively bargain, it also excluded at the local level, local constitutional officers. So if you're thinking about collective bargaining, you're concerned about, you've got a sheriff's office, a sheriff rather than a police department. Sheriff can't collectively bargain. Commonwealth's attorney can't collectively bargain. The circuit court clerk can't collectively bargain. Treasurer, if you're a locally elected constitutional officer, you are not permitted to bargain with your employees. And that the same was true then, the same is true now. I believe Senator Boysko has talked about the preservation of the anti-strike provision, so no concern about folks being able to legally strike. In fact, if employees strike, any public employee at any level, they shall be terminated from public employment and shall not be allowed to engage in any other public employment, not just in your jurisdictions, but in any other jurisdiction or with the state or with any political subdivision in Virginia. Although there's some due process for them associated with that, but that's the basic rule. So choosing collective bargaining or not. And one quick thing to say about the status quo that I have here. I'm sorry, Tim, right here. Thank you. And when I say that sometimes something being optional is not practically optional, the point I make here with the status quo already being redefined by the legislation is just the fact, one, that employees know that this new right exists. They're already talking about it among themselves. They're already engaging their employee organizations to engage you. So it might not be at your door right now, but it could be arriving soon by virtue of just employee desire, employee will, but obviously the decision remains yours. Another thing that I believe has kind of ramped up the interest in collective bargaining among your employees, in addition to the ability to possibly do it now, has been the pandemic. There were working conditions, particularly for frontline workers during the pandemic, that were laid bare. And there were just so many questions that were unanswered by these unprecedented circumstances that many unions told them, well, we can answer those questions for you. We have negotiated agreements that at least purport to speak to these kinds of emergency conditions, or at least they give us the right to negotiate about them once they occur. You don't have that right. You are open to the predilection of the governing body with respect to what happens to you during the pandemic and other emergencies like it. So that too has promoted, I think, more interest than there may have been in collective bargaining among your employees. But it's always a good idea, and it's certainly a good idea in light of the enabled collective bargaining environment that we're in, to kind of take the temperature of your workforce. And I don't mean by that a survey, but from the professionals on your staffs who are supposed to have a feel for this as to whether or not there is unrest, there's dissatisfaction, and there's always some level, of course, of dissatisfaction or concern about terms and conditions of employment. But very often your professional staff, with their ears to the ground, know whether or not collective bargaining is something that their folks are interested in. And it certainly behooves chief administrative officers to listen and know when they hear hoofbeats. Okay, fundamentals of a comprehensive ordinance. And as I mentioned, the state statute that enables collective bargaining is bare bones. Essentially says you can do it if you choose to. There are a couple of absolutes there. One is that any ordinance or resolution that's passed must provide a means by which a union or employee organization is certified as an exclusive representative. That's typically by election. But there are other means, but typically by election, given Virginia law. It also requires, as Senator Boysko mentioned, that the governing body maintain at all times inviolate its right to determine its appropriations and how it spends public money, and therefore the revenues and the revenue mechanisms that feed the appropriation decisions. So any ordinance that would even purport directly or inadvertently to encroach upon that non-delegable authority would be problematic under the statute. Okay, so what is collective bargaining? We've talked about that, undertaking this legal obligation to share decision-making power in the employee terms and conditions area that you didn't have to. It's going to typically define as well who's an employee, and by that, I'm simply getting to who gets to do this. Not everybody gets to collectively bargain for some very important policy reasons that have been illustrated in the long history of private sector collective bargaining. So for instance, supervisors and managers typically are ineligible to collectively bargain. They are the management in labor management relations. Somebody's got to execute the rights that management has and that they secure or continue to retain in collective bargaining. So management doesn't bargain with itself. So typically supervisors, managers, we're not bargaining with you. You're implementing our decision-making and our policies. You define employee organization, which is typically unions or any other association of employees that exists to promote or to the interests of employees. Exclusive bargaining representative, who among those organizations has gone through the process that you specify in your ordinance to become certified, recognized, interchangeable terms, as the only agent through whom these employees in a particular bargaining unit may negotiate with you. And that exclusivity is paramount. And without it, the whole idea and construct of collective bargaining doesn't exist in the traditional sense. Confidential employees, typically excluded. What's a confidential employee? Typically defined under both the NLRA and in most other state statutes as an employee who is actively involved, has some responsibility for executing your collective bargaining mechanics. They're engaged in negotiations or in formulating the positions that you're going to take in negotiating, but they may also support others who do that, so that the administrative professional who is in the meetings, the collective bargaining negotiation meetings, taking notes, or otherwise involved in some administrative support capacity such that they have information about management's bargaining positions and strategy, can be confidential employees. And once again, it's this idea that management has to have some people they can rely on with a level of loyalty, that they're not concerned about spoiling their bargaining position or otherwise creating conflicts with union negotiations. In the 5 minutes I have, I will run through, and we can just go right from here, Tim. Elected officials, we've talked about those folks being excluded. Responsibility to negotiate in good faith. We've talked about certification and decertification. Negotiating in good faith. Once you set up an ordinance, well, the ordinance should provide, again, that's the bedrock of collective bargaining. You cannot pay lip service to collective bargaining. Oh, well, we'll say that we're going to sit down, but we're really not going to agree to anything that we think is just fine the way it is. Minds have to be open, and to the extent there's evidence that management is sitting down at the table or that the union is sitting down at the table without the idea of having a free-flowing, everything that is within the scope of bargaining on the table discussion, possibly be the subject of an unfair labor practice for failure to bargain in good faith. Next slide. And that gets us to the all-important question of the scope of collective bargaining subjects. Once again, the statute is not a place for us to run with respect to anything that really constrains or defines what you may bargain about. You can bargain about everything if you so choose, and unions will tell you that that is the essence of collective bargaining, and to do anything less is not collective bargaining. But there is the idea too that given that you have a blank slate to create collective bargaining in your jurisdiction, to have it be what you say it is in Prince William County, what you say it is in Nottoway, and I'm from Nottoway, I know you're skeptical. Oh, thank you. I appreciate it. I appreciate it. I go back often, so I try to tip carefully. But in any event, you can try to limit it to just money, to just wages and benefits. The pushback that you'll get from unions if you try to do that is significant, but that does not change the fact that it is within your authority to limit the subjects of mandatory collective bargaining. And if I say mandatory is listed here, it is something that you shall bargain about, even if you don't ultimately agree. It's a subject that may be on the table. Permissive, not the same. You bargain about it if you choose to, and you can decide what are the permissive subjects. And then there are prohibited subjects. I talked about illegal subjects, typically the ones that are preempted by other laws and perhaps by public policy in some fashion. We can just run through the rest of these, Tim, and I will be done. Management rights clause could be just as general as we'll bargain about anything that does not encroach upon the inherent responsibility, the sovereign responsibility of management to spend taxpayer money in a responsible way to manage the workforce. Or it can enumerate and list, we're not going to bargain about discipline. We're not going to bargain about hiring and transfers. We're not going to bargain about layoffs. We're not going to bargain about X, Y, and Z. Some ordinances have as many as 20 subjects. Some, as simple as I mentioned before, nothing that inherently encroaches upon inherent rights of management. You've got to find a way to resolve disputes. impasses in negotiation, when you just can't get past something in negotiation, you're at an impasse, there needs to be a means to resolve that, typically by non-binding mediation, and possibly by arbitration, binding or non-binding. In the ordinance. Many of these things can be in the agreement. I advocate for putting as much in an ordinance as you can in order to reduce the number of issues of dispute in contract negotiation and in contract implementation. There is some difference of opinion as to whether or not localities, not so much with school boards, people seem pretty clear that school boards cannot give away, delegate their decision-making authority to binding arbitration. Localities, I believe the weight of the opinions are that localities may do that the Uniform Arbitration Act that Virginia has adopted and that includes or covers public employers permits that. But it's a decision to be made. Unions will want interest arbitration, something that binds the employer to a position because they do not have the ability to strike to enforce their will. Bargaining units, and this will be my last word, Eric, I promise. Question is how many? You're typically always going to have public safety, police, fire as two separate ones, fire and EMS. And then the question becomes, what do you do with the rest of the workforce? Could be professionals, which under federal labor law, professionals cannot be in the same unit as others. And professionals are the people you normally think of. Teachers, if you're school division, engineers, lawyers, doctors. Then others are clerical workers, service workers. Very often I would think, want as few bargaining units as you can reasonably get just for your own efficiency and to reduce the number of negotiating sessions and the number of contracts you have to administer. Because essentially, collective bargaining means that each of these groups gets to negotiate their own personnel policy manual and have their own mini personnel department that has been delegated to managers on the floor and the union representatives of the exclusive bargaining agent. I'll stop there and hope I've left you enough time, Eric. Thank you.
I can talk fast. Slide 27 is where I think I pick up, Tim. So after graduating UVA with Ralph Sampson a real long time ago, I decided to practice law up in Maryland and have spent close to 30 years sitting at bargaining tables with the International Association of Firefighters, American Federation of State County Municipal Employees, or AFSCME, called Federal Order of Police. It has been a very interesting and sometimes lucrative way to make a living. Allowed me to pay out-of-state tuition to send my kids to UVA to William and Mary. But I eventually saw the light and decided to relocate to the Commonwealth. I now live in beautiful Orange County, have an office in Charlottesville, and I kind of split my time between working at home in Orange County, going to the office in Charlottesville, and going back to Baltimore to represent some of my Maryland clients, where I still bargain with unions up in Maryland. So what I want to do in my 10 minutes or so, because I want to give you guys some time for questions, I want to just give you a glimpse of what it may mean for those of you who do choose to enact enabling legislation and allow your employees to collectively bargain. What are some of the things you should see down the horizon, probably the next fiscal year, 23, I guess, realistically we need to start. So if you can go to slide 28. So what do you have to start? What do you do when you start? Well, first thing you got to do is figure out who's on your county team. I do not recommend you have your chief decision makers. You don't want your county administrator or your chief of police or your director of EMS at the table, because they're the ones who can make the decision. You always want to give yourself the out to have the team say, I don't know, we'll need to consult with our decision makers here. But you typically want to have somebody certainly from the department. You want to have an HR person for certain, and certainly folks who have finance knowledge. Maybe not your CFO, but certainly folks who can know the numbers and understand the numbers. Before COVID, I would have said, where you do the negotiations, the easy answer is going to be the county office building. Just spent the last year and a half negotiating by Zoom, Teams, God knows what else. I'm looking very forward to going back to the real bargaining table, which I've been doing more recently, and it's great to be back in person. Figure out, how big the teams are going to be. One of the big questions is, do the employees get paid for their time in bargaining? And it's all over the map. I have Clients in Maryland, in the more rural areas, who are like, we are not spending taxpayer dollars to pay these people to be at the bargaining table. In the I-95 corridor, it's the norm to pay the employees for time in bargaining. You can go to the next slide, Tim. What we often do in the early part of negotiations is we set ground rules. Ground rules are basically something hammered out between the union and the county team. And that will set a time frame for negotiations. It'll spell out what the unions can and can't do with county systems such as email, or if you use one of those other newfangled things, can they use that for communication with membership over union issues? Typically, you add a sequence. Unions want to present the proposals first. County will respond at the next session. Parties can amend, modify proposals up to a certain date, maybe set a cutoff for when you can introduce any new proposals to try to bring this to closure. And probably the hot button issue is, when can you go public? And this obviously is a key issue. You really don't want to have the union running to your board of supervisors meetings during the process. You want to be able to say there's going to be a period of time where we're in Las Vegas, and what happens in Vegas stays in Vegas. We keep it at the table. However, at some point, if you get to an impasse, then parties are allowed to go public. During the process, of course, you're going to have the right on the county side to communicate with your boards of supervisors, agency heads, and you have to give the union some right to communicate with membership as well, give them updates on the status of negotiations. Go to the next slide, Tim. So in terms of basic clauses for the union, this first one here, recognition, that's relatively non-controversial. That's one of the things we can always get a TA. When I say TA, I mean tentative agreement. We get that pretty quickly. It's essentially who is in the bargaining unit, and then what's covered. And what's covered in the agreement is going to be spelled out in your enabling legislation, as Cynthia was talking about. And I cannot emphasize that point enough for everybody in this room, and for those of you who go back and tell others about it. Your enabling legislation becomes your constitution. It tells you what you can and cannot bargain over. And in Maryland, it's not dissimilar from what Virginia law is. Every county and city has its own separate enabling legislation. And some jurisdictions are very broad. They allow bargaining on everything. Some are very restrictive. And that's what's going to be the same model Virginia seems to have adopted. Second bullet here is union security. There's two really important things here. One is dues checkoff. Unions always want to get a dues checkoff. Makes perfect sense. This is how the unions collect their money from the membership. They need to be able to have a means other than knocking on people's doors or hounding people. So they want dues checkoffs, but you do not necessarily have to provide that. And some jurisdictions actually prohibit it. State of Michigan prohibits public sector unions from having dues checkoffs. In Indiana, the law requires that the jurisdiction first get express consent from the employee, not just something signed out from the union, but the jurisdiction has to go get their own authorization on top of that. So dues checkoffs are always a hot subject. The first things the union's going to ask. Union membership. I don't know how many of you are familiar with the Supreme Court case called the Janus decision. It came out about 3 or 4 years ago. It essentially requires that public sector employees nationwide be treated as if they're in a right to work jurisdiction. They cannot be forced to pay union dues. They can't be forced to pay a more limited agency shop or service member fee. They have the First Amendment right to opt out and say, I do not want to pay anything to be in this union. So that's the Janus decision. I do not expect that to be changed anytime in the near future, given the current makeup of the Supreme Court. So that's something which is going to be covered by the unions. And then the last bullet here is time off for union business. That's again this hot issue of you want to have taxpayer money paying employees who are going to union meetings, and it's very much jurisdiction to jurisdiction in Maryland. Next slides are management stuff. Cynthia talked about management rights, very important. Sometimes your enabling legislation will spell out what your management rights are, and you can simply cross-reference and say in your collective bargaining agreement, that our jurisdiction reserves to it all rights expressly authorized under enabling legislation section XYZ. Sometimes you get more specific. I've seen sheriff's departments in Maryland, sheriffs can collectively bargain. I've seen sheriff's departments go through in very, very great detail about what is reserved to the authority of the sheriff. Sheriffs don't like to give up a whole lot of authority to the unions. They want to be able to retain that. So sometimes spelled out. No strike, no lockout clause. It's statutory in Virginia, so you put it in the contract. It doesn't make a difference because folks can't strike anyway. And there's a savings clause, which basically means if it's not in the agreement, then we can't go back and reopen things unless you agree otherwise. So I'll quickly run through some economic and non-economic terms. The big ones, of course, are going to be your wages, and that can be the COLAs, cost of living adjustments, your merits or steps. Some jurisdictions call them merits, some call them steps. And then you have longevities. In Wisconsin, interestingly enough, after Governor Walker changed the law, whatever it was 10 years ago, the only thing you can bargain in Wisconsin is wages. And your wage increase cannot exceed inflation in Wisconsin, which until 6 months ago, people were like, wow. Now they're okay, I'll take inflation. Again, you could choose to do that if you wanted to. And Governor Walker, he gets carve-outs for public safety, but that's what it is for non-public safety employees in Wisconsin. Wage reopeners, we do this all the time in Maryland negotiations, where you don't agree to a multi-year deal. Now is a good example of when you would do it. I mean, there's two issues with multi-year deals. One is you're binding a successive legislative body, you're binding next year's board of supervisors to something that they may not agree to. And then the other issue is obviously with inflation, you don't know where wages are going to be in 2 years. So a lot of times you'll have a 3-year contract with annual wage reopeners, health insurance, and then retirement benefits. Those are the other big ones. Retirement includes all the subcategories of pension or 403B or OPEB, drops. Those of you who are in public safety might know what a drop is. It's a deferred retirement option program where police officers or corrections officers can keep on working but collect their pension while they're working. It gets put into a special account. Again, as I've said a half dozen times, you can exclude this from bargaining. Pensions are huge issues. I spent almost an entire negotiation last year with the IAFF solely on the issue of do we increase the pension multiplier from 2.0 to 2.5. IAFF really wanted a 2.5 multiplier. They gave up a whole lot to get it. And it's a big issue, but you can carve out pension. I have some jurisdictions in Maryland where they can't negotiate pensions. Next slide, Tim. So then you have your more perhaps less controversial economic issues, and it's going to be everything overtime to shift diffs to leave, callback pay, etc. Again, I have some jurisdictions negotiate this, some pull it back. Again, it seems like the sheriffs in Maryland like to pull back the authority to control leave and whatnot. On the other hand, for those of you who are familiar with the way public safety works, and especially your EMS and fire suppression personnel, leave is a huge issue for those folks. Next slide. So now we get to some of the non-economics. Hours of work. Once again, talking public safety. Your EMS and your fire suppression, I mean, 24/72 schedule is the gold standard. Everybody wants 24/72, but and again, I've seen department or unions give up a whole lot to get a 24/72 schedule. That's the kind of thing you can negotiate. You could even negotiate what your FLSA overtime schedule is. You want to go with a 28-day 212 or a 14-day 106. So these are the kinds of things that would be in hours of work negotiations. Seniority, of course, layoffs. A lot of union management committees come up, and then Weingarten rights you might hear about. That's something which does not apply in the public sector. That's a National Labor Relations Act private sector right. It's the right to have a union representative present with an employee. When the employee believes they may be subject to discipline. That's something which, because it's not expressly in the law in the public sector, unions often ask for that in the contract. Then finally, grievance and arbitration, which is your dispute resolution process in the event of any kind of a challenge where the union contends that the employer has not complied with the CBA. So I think I almost got in at the 11 o'clock wire. I think we're wide open to questions.
All right, we got about 10 minutes for questions. We have questions for the panel. I am going to ask that you come somewhere near the microphone so that people online can hear your question. Just let us know where you're from, who you are.
Vic Angry, Princeton County. Well, thank you, first of all, for this presentation. This is one that I've been researching thoroughly, personally. So you heard me say that I don't support it. It's not that I don't support it, because I support all of our employees, and that's the thing for me as a retired military. It's one of the leadership things we talk about, chain of command, this whole thing. But for me, in very specific, it is the IAFF portion. I have about 500 what I call volunteer employees. And I know we don't call volunteers employees, but I think that's something that we need to work on to change, because these are volunteer firefighters. I happen to be one of them. And there's been this big, dispute, if you will, when we talk about fire and rescue in this system of paid versus non-paid. So as we write this out, I just want to be very specific in making sure that I don't do something that has unintended consequences of literally pushing volunteers out of what volunteers love to do. And there is a cost saving to that. There is all of this, but oftentimes that population, that group of folks has gone unlooked or overlooked. And so as we go down this road, and I don't know what you know about the relationship in fire and rescue between paid and non-paid firefighters, but it's a very disrespectful one. Let's just put it like that. And so I want to be very careful and cautious about how do we do this. And I'm specifically speaking on fire and rescue. I know that our public employees and our police have the same thing going. And so that one thing I don't want to tie to everything, but if it's all tied together, then I have to be very clear about what it is that we're going to do in Princeton County with our fire and rescue system. So I don't know if people.
If it makes you feel any better, in Maryland, there's a tension between the volunteers and the professional fire and rescue as well. And it's a huge issue. I spent a negotiation a couple of years ago primarily on that issue. And the professionals were very protective, but they didn't want their professionals serving as volunteers or serving up a certain rank. So yes, it's a very hot issue. No pun intended.
I was just going to say regarding the volunteer versus paid situation, it reminds me a bit of the conversation around in collective bargaining around employees who are within a bargaining unit eligible to bargain and those who are not, and whether or not there will be some lack of parity between those groups. And what's very often said is the old saying of a rising tide lifts all boats, that it's employers hard pressed to do for one group of employees who are eligible to bargain something that it won't perhaps do for people who do something very similar, but who by virtue of certain provisions in the ordinance are not bargaining eligible. So for instance, if you're talking fire service, largely you're not talking about money, you're not talking about benefits in terms of parity because of the nature of volunteer service, but you are talking about working conditions, and you are talking about equipment and safety rules and those kinds of things, which I would think locality would be hard pressed to not somehow try to extend to volunteer companies as well, to the extent the law allows and the volunteer company permits.
So that's just an important distinction, right? So we talk about collective bargaining, bargaining with their employees.
Not the volunteers.
Simply just a observation, which is in Virginia, typically volunteer providers are volunteers to a separate 501c3, which is
Yeah.
Sure.
Yeah, thank you. I have two questions. And Ms. Hudson, you alluded to this a little bit. This is all very new in Virginia, and so different attorneys will have different views. But one of the outstanding and big questions right now is if a county or locality does binding arbitration in the ordinance, do we think that's going to be turned over because of the Dillon rule issues that exist already as far as binding arbitration? That's the first question. Second question, something that I wrote the words you said down specifically. You said, in your opinion, you like as few bargaining units as reasonably possible, as you can reasonably get. question we're having in Loudoun County right now is specifically about what we have another unit for labor and trade that we don't have for clerical, professional. They would all be in one unit, but labor and trade would be the only other unit outside of public safety. So for both of you, I would like your opinion on that.
You want to start on the first question about the?
I'll start on the first question about arbitration, binding arbitration, and whether or not it could truly be enforceable if you put it into an ordinance, or whether or not that part of the ordinance would be contrary to the Dillon rule. I don't know, but I will, let me just say that at the outset. But what I have relied on, and what most of us will likely have to rely on, absent a pronouncement from the Supreme Court, Virginia Supreme Court, or some elaboration on this by statute, our Attorney General's opinions. The Attorney General did issue an opinion. I think it must have been back in March of this year, about the tension between the mandatory grievance procedure for local government employees. Title 15.2 prescribes a grievance procedure that all local governments must put in place with certain minimum requirements. You can give greater rights, but you can't get even lesser rights than what's in that statute. And the question that was put to the Attorney General about whether or not then you could negotiate a different grievance procedure pursuant to address discipline and adverse personnel actions by way of collective bargaining. And essentially the AG said yes and no. Yes, you can negotiate a grievance procedure in collective bargaining, as long as it at a minimum meets those requirements of Title 15.2. And to the extent you want to embellish that, as long as it's not inconsistent with 15.2, fine. And then the other question was whether or not that grievance procedure could culminate in binding arbitration. And the answer was yes. Others have relied not just on the Attorney General's pronouncement, which does mention the Uniform Arbitration Act, but they've relied on the Uniform Arbitration Act itself, which has been extended in certain circumstances if the governing body chooses to apply to the governing body. And I believe as long as the governing body recognizes that binding arbitration cannot bind them with respect to a spending decision, then I think they're probably okay.
I'll tackle the bargaining units question. So that is a really good point. And it's not unusual to see 3 bargaining units, which are going to be your police, your fire, and then your public works folks. And what I've typically seen is the clerical folks are rolled in with the public works. Sometimes I've seen them carved out. Sometimes the clerical who work in public safety are put in with the public safety unit. And the problem you run into when you have multiple units is, we call it whipsawing, or sometimes the unions play off each other. What I see in contracts a lot of what's called a Me Too clause. It has the different meaning from Me Too in the sexual harassment context. If you're giving the police that, then the fire personnel want to get that too. And then the folks who represent by asking, like, well, wait a minute, we work just as hard as those police and fire do. Why aren't we getting that? So that's the risk you run into when you have multiple bargaining units. And the unions, they do communicate with each other, and there is a jealousy because everybody feels like they work just as hard and their life is put just as much at risk as the other guys. So that, I think, is where Cynthia's coming from when she says try to keep your number of bargaining units to a minimum to avoid being whipsawed between the unions.
And let me just say too, this is something that kind of colors my comments in those kind of gray areas, the no man's land areas that we haven't yet explored, is more conceptual than it is based on black letter law. And that is the fact that no local government in Virginia has seriously or legally collectively bargained since 1977. The unions have been doing it every day since 1935. Basically, or certainly the early 50s in the public sector. There's an imbalance of experience here I think that is helpful to take into account as you decide how expansive to make your collective bargaining ordinance, if you're inclined to enable collective bargaining at all. Management staff, you have human resources departments where people have never worked in a unionized environment. You have police departments where the police chief has never worked in a unionized environment. And there's a lot of catching up that public employers in Virginia have to do in order for the bargaining strength, I think, to be equal. It's like an engagement around drafting these ordinances. You know, union representatives are on one side, and staff is ably trying to keep them engaged and get their input on the other. And the unions are very often saying, no, you can't do that because that's just not how it's done. Just take our word for it. That's just not how it's done. This isn't collective bargaining. We say this is collective bargaining. And I've kind of been the voice that said, you get to say what collective bargaining is, county, city, town. You really do, no matter what the NLRA has said it is, because it does not apply to you. What the General Assembly has said applies to you. And the General Assembly has said, you enable it, you make it what you can live with. So with that in mind, I've talked about, fewer bargaining units than, 10 or 15. But interestingly, and the folks in Northern Virginia know this, there's SEIU on the one hand and there's AFSCME on the other. In conversations with AFSCME, they've wanted as many as 8 bargaining units. And sometimes they were on that end of the spectrum. SEIU was on the other end, police, fire, and everybody else. And you can fathom for yourself, what the difference in position is there. But I'm sure it, speaks to their interests in ways that probably Eric and I could talk about in another session another year.
We are out of time. Let's thank our panel for their